what the Constitution says. When does the President of the United States have to get permission from Congress to use military force?
Generally, Senator, my understanding is the divisions between Article 1 and Article 2 distinguish between the war powers, which are under Article 1 and require congressional consent. Again, talking in great generalities, whereas other use of force, if I understand your question, are things that are likely committed under Article 2 to the President's commander-in-chief powers.
I have no idea what you just said, Mr. Hendershot.
Welcome back to Freedom Forge. If you're new here, hit that like button and subscribe because we break down what's really happening in Washington without the spin, without the media filters, and without the political games. Today, we're reacting to a Senate hearing that cuts right to the heart of constitutional law, presidential power, and whether the people sitting in positions of authority actually understand the Constitution they're supposed to defend. In this exchange, Senator John Kennedy questions a nominee about when a president of the United States needs Congress's permission to use military force, along with broader questions about property rights and racial classifications under the law. And let me tell you straight up, what you're about to hear is exactly why Americans are losing trust in institutions.
Senator Kennedy.
Thank you, Mr. Chairman. Mr. Hendershot, when does the President have to get permission of the United States Congress to use military force?
Well, Senator Kennedy, as I was discussing with Ranking Member Durbin, I do want to be careful about hypotheticals in terms of prejudging.
It's not a hypothetical. I'm asking what the Constitution says. When does the President of the United States have to get permission from Congress to use military force?
Generally, Senator, my understanding is the divisions between Article 1 and Article 2 distinguish between the war powers, which are under Article 1 and require congressional consent. Again, talking in great generalities, whereas other use of force, if I understand your question, are things that are likely committed under Article 2 to the President's commander-in-chief powers.
I have no idea what you just said, Mr. Hendershot. Let's try it again. Tell me when the President has to go to Congress to get permission to use military force.
Senator, I think is when, because the text of the Constitution, Article 1, talks about declarations of war, those would be circumstances where the President would, in a general sense, and use of force that is not war under the commander-in-chief power, I think those are under Article 2 without the consultation of Congress.
Okay. I'm sorry, I don't mean to be rude. I just don't understand what you said. Mr. Jones. Let's suppose the mayor of a city, strike that. Let's suppose the mayor of a city goes to his or her city council and gets a rule freezing rents. You with me?
Yes, Senator.
Freezing all rents
Yes, Senator.
forever and a day. Let's make it even more interesting. Reducing rents by 20%, because housing is a problem, right? Cost of housing. Let's suppose to try to help people with housing costs, the city, mayor and council, uses its police power under its state constitution as recognized by the federal constitution. So we're going to lower our rents by 20%. And as a result, because of the cost of insurance and electricity and that sort of thing, about half of the landlords in the city just say, look, we're going to have to default on our mortgage. Constitutionally, can the city do that?
Well, Senator, I think it could depend. I do think the city could have some ability to freeze rents. But I think you would have to look at the.
Why isn't that a taking?
Well, it certainly could be a taking. And I think,
When does it become a taking? At what point?
well, I think it would have to be, you'd have to initially look at the impact, the financial impact on the taking of
Okay.
what could amount to a
Let's
property.
suppose, that's fair, yes, sir. Let's suppose 40% of the landlords will default on their mortgage. Have you reached the point of a taking or not? And how do you determine when you reach the point of a taking?
Well, again, I think it could depend, but there would have to be a showing that, what the financial impact was, and I think.
Yes, sir, I'm sorry, I don't mean to be rude, we just have so little time. I understand that you have to have a showing. Tell me what the rule is.
Well, I think the rule is if you're taking property without, the government, I should say, taking property for a legitimate government purpose, I think you can only do that by compensating the owner of the property.
So
Generally-
any freeze on rent is a act of eminent domain? Is that
Well,
what you're saying?
not necessarily, Senator. I think in your hypothetical, you were, at least as I understood it, we're talking about a financial impact, not just freezing it at the moment, but then going on down the
Okay.
road.
In the hypothetical I gave you, who's going to win if the landlord sue the city or the landlords?
Well, I think, again, it would depend on the
You're
length.
not going to give me an answer, are you?
Well, I think it could depend. I know that's a very lawyerly answer, Senator. but I
Yes, sir, it
think-
is,
I
very
think it
hard.
would depend on-
Judge, let me ask you a question in the few minutes I have. Tell me under what circumstances the state legislature can draft a statute that makes a distinction that classifies people on the basis of race.
Senator, I think, Chair Grassa, may I answer?
Yes, and then we'll go to Senator Goins.
Thank you, Senator. I think the circumstances would depend on the specifics of United States Supreme Court
I
case
know.
law and
Just give me
the
some
state
examples. Just give me
constitution
some
at issue.
examples.
Senator, on the basis of race, I don't think, I think in United States Supreme Court has held that there should be no classification.
No, they've just said you got to have a compelling reason.
That is true, Senator.
So tell me what would be a compelling reason.
Senator, as we sit here today, I cannot give you a compelling reason.
Okay, I appreciate your honesty. Thanks, Mr. Chairman.
Thank you.
Right out of the gate, Kennedy asks a very simple, very fundamental question. When does the president have to go to Congress before using military force? That is not some trick question. That's basic constitutional knowledge. Article 1 gives Congress the power to declare war, and Article 2 makes the president the commander-in-chief. This is foundational. Every first-year law student should understand this tension. But what we see in this hearing is hesitation, confusion, and what can only be described as legal word salad. The nominee dances around the answer, talking about generalities and distinctions without actually giving a clear rule. And Kennedy, to his credit, doesn't let it slide. He presses again. He simplifies the question. He tries to pin down a clear answer. Because here's the reality. This isn't just academic. This is about war. This is about American lives. This is about whether one person can send troops into harm's way without the consent of the people's representatives. What frustrates people watching this, and frankly, what should concern you, is that the nominee never gives a direct, confident answer. Instead, we get the classic, it depends. And look, yes, law can be complex, but there are core principles that shouldn't be this hard to explain. Then Kennedy shifts gears and brings up a hypothetical about rent control. Now some people might think this is off topic, but it's actually brilliant. He's testing whether the nominee understands the concept of a taking under the Constitution, whether the government can interfere with private property without compensation. Again, the same pattern. Hesitation, uncertainty, it depends. No clear standard, no firm grounding in constitutional principles. And Kennedy keeps pushing because this matters. If the government can arbitrarily reduce rents and cause massive financial losses to property owners, at what point does that become unconstitutional? That's not just theory, that's people's livelihoods. But it doesn't stop there. The most revealing moment might be when Kennedy asks about racial classifications under the law. Now, this is critical because the United States Supreme Court has been very clear. Any law that classifies people based on race must meet the highest level of scrutiny. You need a compelling government interest. So Kennedy asks a simple follow-up. Give me an example of a compelling reason. And what happens? The nominee admits they cannot give one. Think about that. Someone being considered for a high-level legal position cannot articulate a basic example of when race-based classification might meet constitutional standards. That's not a minor slip. That's a major gap. Now let's step back and look at the bigger picture. This hearing isn't just about one nominee. It's about a pattern we're seeing more and more, people being elevated into powerful roles who struggle to clearly explain the Constitution. And if you don't understand the Constitution, how can you defend it? From a right-leaning, constitutionalist perspective, this is exactly the concern. The Constitution is not supposed to be flexible clay that gets molded depending on political trends. It's a fixed framework designed to limit government power and protect individual liberty. When answers become vague, when everything depends, that's when government power expands. Because ambiguity always benefits those in power. And Kennedy's style here, some people call it blunt, some call it confrontational, but what he's really doing is forcing clarity. He's cutting through the legal jargon and saying, explain it in plain English. Tell the American people what the rule is. Because at the end of the day, this isn't about scoring political points. It's about whether the people making decisions about war, property, and equal protection actually know the rules. And if they don't, that's a problem. So when you watch this clip, don't just see it as another Senate hearing. See it for what it is, a test. A test of knowledge, a test of accountability, and a test of whether our institutions are still grounded in the Constitution. If you believe in limited government, if you believe in the rule of law, and if you believe the Constitution should actually mean something, then moments like this matter. Let me know what you think in the comments. Did the nominee answer these questions well? Or is this a sign of a deeper problem in Washington? And don't forget to like and subscribe to Freedom Forge.